Welcome to Kent County Levy Court Special Business Meeting. Today is Wednesday, November 6, 2024. We're in Levy Court Chambers, room 203. Before I open the special business meeting, I'll turn this over to the Acting County Administrator to describe how those that would like to join us by phone and or WebEx can do so. Sir?
Thank you, Mr. President. This meeting is being held in person at 555 Bay Road, Dover, Delaware, and Levy Court Chambers. We also are making it via the internet through WebEx. Participants can join us by phone or by computer during the meeting. There will be opportunities for public comment for those attending in person or online. When the President opens public comment period, those attending in person may step forward to one of the two podiums and be recognized. If you're joining us by phone and wish to comment, please press *3, which will raise your electronic hand. Our operator will identify you and bring you into the meeting. Pressing *6 will mute and unmute your line. If you're online, you will see a hand and a microphone icon at the bottom of your screen. Please use those at appropriate times. We ask guests to begin public comments by stating your name and address for the record. The county administrator will administer an oath of affirmation to anyone giving testimony during a public hearing. We ask that the public comments relate to the subject announced by the president. This meeting will be recorded and will follow all rules and procedures adopted by Levy Court as well as the Mason Rules of Order. Back to you, Mr. President.
Thank you. At this time, we'll call the special business meeting to order. I'll ask Commissioner Maston to lead us in the invocation, Commissioner Angel, Pledge of Allegiance, and moment in silence for our troops and first responders, Commissioner Sweeney. All rise, please.
God, we pray that you would help them and all the decisions that we make today to make right and good and wise decisions for all. Amen.
Please remain standing for a moment of silence for our military, law enforcement, firefighters, paramedics, and other first responders who have given their lives in the line of duty. Thank you.
Thank you. At this time, I'd like to have a roll call to determine quorum, please. Mr. Naka?
Mr. Angel?
Present.
Mr. Hall?
Present.
Mr. Hertz?
Here.
Mrs. Maston?
Present.
Mr. Scott?
Here.
Mr. Sweeney?
Here.
Mr. Pepper?
Here.
Mr. President, roll call reveals 7 yeas.
Thank you.
Present.
Thank you. We do have quorum. All commissioners are here. County attorney's here and the acting county administrator. Prior to the adoption of the agenda, I need to add a section for public comments at the conclusion of the public hearing. I need a motion to that effect.
So moved, Mr. President.
Second.
Thank you. Any questions on the motion? If not, can we have roll call, please, to add that?
Mr. Angel?
Yes.
Mr. Hall?
Yes.
Mr. Hertz?
Yes.
Mrs. Maston?
Yes.
Mr. Scott?
Yes.
Mr. Sweeney?
Yes.
Mr. Pepper?
Yes.
Mr. President, roll call reveals 7 yeas.
Thank you. The motion passed. Need a motion on adoption of the agenda for this evening.
So moved, Mr. President.
Second.
Thank you. Motion by Commissioner Angel, second by Commissioner Sweeney. Any questions? Seeing none, can we have roll call, please?
Mr. Angel?
Yes.
Mr. Hall?
Yes.
Mr. Hertz?
Yes.
Mrs. Maston?
Yes.
Mr. Scott?
Yes.
Mr. Sweeney?
Yes.
Mr. Pepper?
Yes.
Mr. President, roll call reveals 7 yeas.
Thank you. Any commissioners have any questions prior to opening the hearing? Seeing none at this time, we will open the public hearing. The hearing is for Mr. Kenneth Decker, hearing regarding preliminary notice for removal. So at this time, I'll turn the public hearing over to Mr. Decker. Mr. Decker's attorney.
Thank you, President Pepper. Good evening, commissioners, members of the administrative staff, Mr. Elias and Mr. Stafford, as well as members of the public. My name is Dan Griffith. I'm a lawyer with the law firm of Whiteford, Taylor, and Preston, and I have the privilege of representing Ken Decker in connection with this proceeding. For the edification of the public, what we're here for tonight is a public hearing on a notice of removal of the appointment of Mr. Decker as the county administrator. That preliminary notice of removal was October 1. The application that you guys will be considering after this will be whether that preliminary notice of removal should become a final notice of removal. I prepared tonight a presentation, and the purpose of my being here tonight is to demonstrate for the commissioners and for all present that that the commissioners' attempt to remove Mr. Decker as the county administrator has been unlawful. It has been unlawful under state law. It has been unlawful under federal law. It has been unlawful under multiple state laws. It has been unlawful under multiple federal laws. And I hope to demonstrate that for you tonight, both through my presentation and through Mr. Decker's testimony. So when I say state laws that have been violated and federal laws that have been violated, here is what I'm talking about. There is a state law, 9 Delaware Code 4108, that defines the role of county administrator and sets forth the process if the county is interested in removing Mr. Decker as the county administrator. The method of termination that the commissioners have attempted has been non-compliant with 9 Delaware Code 4108. And I will describe in a few minutes how the commissioners' efforts have been non-compliant with the method of termination. In addition, 9 Delaware Code 4108 sets forth why the reasons that the commissioners must use to terminate the position of county administrator. The statute says pretty definitively that there must be reasons to remove the county administrator. On October 1, the county commissioners voted to remove Mr. Decker without cause. That is a violation of state law. There must be cause. The third Delaware statute that's been violated by the commissioners is the FOIA statute, 29 Delaware Code 10004, the Open Meetings Act. That's been violated in multiple ways. Number one, the agenda that you saw does not include an opportunity for public comment. The form used by the county includes a public comment section. The law requires public comment. I heard today that the agenda is going to be amended to include public comment. That is the first time the public has received notice that they are permitted to comment publicly. In other words, Mr. Decker never got the opportunity to advise people who would come here and provide comment on his behalf that they are entitled to do that, because according to the agenda, there was no public comment. That, ladies and gentlemen, is a violation of FOIA. It's a violation of the Open Public Meetings Act. It's a violation of Mr. Decker's due process rights. He did not have the opportunity to bring witnesses here for him for public comment. You can't amend the agenda the night of the meeting to add public comment. You can amend the agenda the night of the meeting for issues that arise during the meeting. You can't amend the agenda to comply with a law that's been on the books forever and that you've known about forever, and it's part of the form for the agenda. It's upsetting that the agenda did not provide for public comment and was amended tonight to provide for that public comment. It's a basic provision of the Delaware Open Meetings Law that public comment is permitted. It should have been included on the agenda. The fourth Delaware state law that was violated by the county in connection with the effort to remove Mr. Decker is the Delaware Whistleblowers Protection Act. Mr. Decker provided, and we provided on Mr. Decker's behalf, a written reply to the notice of the preliminary determination. And in that reply, we described how we believe, and we believe the evidence will support, that the basis for the county's removal of Mr. Decker as the county administrator is not without cause. It's because he blew the whistle on the county. And when I say blew the whistle, what he did was he reported an ethical violation, not by one commissioner, by all of the commissioners. He reported an ethical violation to the Public Integrity Commission. Now, he didn't make a complaint. He didn't argue that there was an ethical violation. He made a referral. He simply asked the Public Integrity Commission to look into an issue. And when they did look into the issue, the Public Integrity Commission not only concluded that there was, in fact, an ethical violation, but commended Mr. Decker for bringing that to their attention. It was an extraordinary opinion. And not long after that, the retaliation towards Mr. Decker for reporting this ethical violation escalated to the point where ultimately, on September 24th, there was a vote by these commissioners to remove Mr. Decker from office. One issue on that September 24th vote. As I mentioned, 9 Delaware Code 4108 describes the method by which a county administrator may be removed from office. the first thing the county must do is do a preliminary notice of removal. As the commissioners know, that wasn't done. The first thing the commissioners did was vote to remove him in violation of 9 Delaware Code 4108. So, as the commissioners are aware, you had to go back and do a do-over. Because you had violated the state law originally by throwing out Mr. Decker without providing a preliminary notice of removal, without complying with the statute, you had to start all over again and do the preliminary notice of removal. Your minds were already made up. So complying with the statute post hoc was not helpful. So those are the state laws that have been violated in connection with the efforts to remove Mr. Decker. There's also been 2 federal laws violated. Mr. Decker has a 14th Amendment right to due process of law. He has a property interest in his employment. That property interest cannot be deprived without due process of law. There has been a panoply of violations of his due process rights in connection with this, and I'll go into them as we go further. But his 14th Amendment due process rights have been violated in connection with the county's efforts to remove him. His First Amendment rights, he has a right. He had a First Amendment right to refer a matter to the Public Integrity Commission. You could argue, and it would be accurate, he had an obligation to do that. He provided the opportunity to the commissioners to make that referral or to even comment on the referral. Everybody was silent. It was crickets. He had a First Amendment obligation and a right to refer to the Public Integrity Commission. He did it, and he got fired for it. That's a violation of his First Amendment rights. So we have a litany of state and federal laws violated in connection with the county's efforts to remove Mr. Decker as the county administrator. Now, how did we get here? A little bit of background. Mr. Decker came to the county in 2023. He had an incredibly distinguished background. The prior county administrator had been here about 16 or 17 years. He was entrenched. And there was, as you would have for somebody who's been here 16 or 17 years and commissioners who have been here for many years, a way of doing things. And we're going to hear a little bit about the way of doing things before Mr. Decker came on board. But you can see here on this slide some of Mr. Decker's background, an incredibly impressive background in public service, in management, in leading people. And he was decorated for all of that. So in 2023, Mr. Decker is hired as the county administrator. And the way that things had been going before his hiring started to change. When here's the statute, the provision of the statute that applies to Mr. Decker. He was appointed. This isn't like a hiring. There is a difference between an appointment and a hiring. An appointment is to a specific position. The statute provides that Mr. Decker was appointed. During the interview process, during his final interview, he made it very clear to the commissioners, because he knew that through his years of public service, there are times when the county administrator is asked to go along with the way things had been going. And Mr. Decker made it clear to the commissioners during the interview process, as early as the interview process, that if they were looking for somebody who would be ethically flexible, they had the wrong guy. So that's what Mr. Decker was confronting when he was hired, an entrenched culture. And the culture was as follows: a lot of backroom dealing, a lot of secret deals, not a lot of transparency, some favoritism, and some morale issues. And Mr. Decker had to address all of those things, and he did. Early in his tenure, in March of 2023, it came to Mr. Decker's attention during the course of a meeting that the county commissioners were considering a long-term lease for a property worth about $920,000. And the lease was going to be for the cost of $1 per year to the Polytech School District. The commissioners are obviously aware of all of this. This is mostly for the benefit of the public attendees. And in connection, obviously it's very favorable terms for the school district. It came to Mr. Decker's attention that not only was there a commissioner who worked for the school district, but there was a family member of that commissioner who worked for the school district. A layperson can understand that that is problematic, that that is a conflict of interest. Now, it's not an insurmountable conflict of interest. It would just mean a recusal. And if there were enough commissioners to vote in favor of the long-term lease without this particular commissioner, it wouldn't have impacted anything. It would just be a matter of public disclosure of a conflict of interest and a recusal from voting on that particular issue. But there was none of that. It was business as usual. It was a commissioner with a self-interest voting on a matter in which he was personally involved. So, after Mr. Decker gave the opportunity to the commissioners to either address this issue directly with the commissioner or make a referral to the Public Integrity Commission, nobody did anything. So it was incumbent upon Mr. Decker, again, not a right he had, not an option he had, it was an obligation he had as the county administrator to make an inquiry about this issue to the Public Integrity Commission. And so he did in March of 2024. The referral itself is in the documents that we provided as part of our exhibits, but I wanted to offer some excerpts from those documents. This excerpt, it makes clear that Mr. Decker was not accusing anybody of anything. He was not pointing the finger. This was not a report of misconduct. This was a referral to answer a question. What he put in his referral was, to be clear, I offer no opinion whether the commissioner's employment and/or familial employment with the Polytech School District constitutes a conflict of interest, nor do I suggest or imply any wrongdoing related to the district or the property. I simply believe the best interests of the county are served by asking the commission for guidance. And that's about as open-ended as it gets. Again, non-accusatory, simply asking a question. Again, Mr. Decker recognized, given his experience in public service, that meeting his obligations isn't always easy, that making a referral to a Public Integrity Commission is not always going to be met with applause by the people who are the subject of the referral. So he mentioned in his referral, I hope that the commissioners would have referred this matter to the Public Integrity Commission before now. Again, he gave the opportunity to the commissioners to make the referral. That apparently has not happened, and it leaves me in the unenviable position of making a referral that risks negative professional consequences. Mr. Decker's not naive. He knows that when you make a referral to a Public Integrity Commission of people on a public body who have the ability to remove you from that position, you are risking retaliation. He knew it as early as March of 2024 that he was running that risk. So here's the decision, which is also in your packet of materials. It is, I would suggest to the commissioners, extraordinary. The commission met on May 21, 2024 to discuss whether you should recuse yourself from matters related to Polytech School District while performing your county duties. After consideration of the relevant facts and circumstances, the commission decided that your employment and that of a family member at the Polytech School District creates a conflict of interest which mandates your recusal from the Kent County Levy Court decisions regarding the Polytech School District. Now again, there have been multiple votes by that commissioner on this particular issue. No recusal. It was a complete vindication of the referral and a complete rebuke of the commissioners. In my experience as an attorney, I've never seen the next sentence from a Public Integrity Commission. Mr. Decker was the only county employee or commissioner who stepped forward to bring this matter to the commission's attention, and then going further, even without identifying the above financial interests, it was clear to the commission that you were personally invested in the Polytech School District to such a degree that it affected your professional judgment. Apparently frustrated at the length of time the county was taking to make a decision about the Polytech land lease, you took matters into your own hands by covertly holding a meeting with the Polytech District officials without notifying the county administrator and some of your fellow commissioners. That behavior is indicative of impaired judgment, as was your unwillingness to seek an advisory opinion from the commission when asked to do so. From the public's perspective and this commission's perspective, a county commissioner voted on a matter in which he had a conflict of interest. The commissioner was told he may have a conflict of interest and was asked to seek advice, but refused to do so. The public and this commission are left to wonder why. Now, this is the section that is unprecedented in my experience. The commission also wishes to commend Mr. Decker for contacting the commission. As a new county employee, it is unlikely he envisioned the scenario where he would be the lone voice advocating for an opinion from the State Ethics Board in the face of staunch refusal. That is a strong rebuke of the commissioners, a strong commendation to Mr. Decker, and it ultimately cost him his job. Knowing that this issue had now percolated and the decision from the Public Integrity Commission had been received, it was a stronger campaign against Mr. Decker's employment as the county administrator. There were emails that are in the record directed toward Mr. Decker, advising that he shouldn't have published to the commissioners, to the very people who were the subject of that referral. He was rebuked for sending that decision to the commissioners. Astonishing. Then, as if it wasn't already clear that the commissioners were retaliating against Mr. Decker for making a referral to the Public Ethics Commission, in that email, that very same email, there was a reference to a prior allegation that somebody had alleged that Mr. Decker had engaged in some type of bullying, this bullying narrative. So it warrants mentioning about this bullying narrative because it was used to try to justify the retaliation against Mr. Decker. The bullying allegation was this. A non-county employee said that Mr. Decker, and he'll explain this in his testimony, had been stern or strict with her. And that complaint warranted some investigation. You know who wanted the investigation the most? Mr. Decker. And you know who wanted it public? Mr. Decker. It was being used to retaliate against him, but when he was confronted with it, what he asked for was a public hearing and an outside investigation of him. He asked to be investigated. And as soon as he did that, as soon as he said, come, here I am, ask me anything you want, let's have a public investigation of this by an outside objective source, it got dropped because it wasn't a legitimate investigation of bullying. It was a pretext to retaliate against Mr. Decker for making the referral to the Public Integrity Commission. So now we fast forward from June, when the Public Integrity Commission makes its decision, all the way to September, 2 months ago. Mr. Decker presents to the commissioners a proposed reassignment of an employee from the finance department to the administrative department. Any fair reading of 9 Delaware Code 4108, or any fair understanding of the relationship between a county administrator and a levy court would know that that's completely within his province. That is squarely within the job of a county administrator, the reassignment of an employee from one department to another. He is the lead administrative official. The commissioners develop policy, legislative and judicial, quasi-judicial, but administrative, that's the job of the county administrator. But when he raised that, and even when he raised that, this is within my province, this is something I'm permitted to do during the September 17th meeting. And there was pushback from the commissioners that this is not within, you're acting as if we work for you, not vice versa. Mr. Decker asked the solicitor, said, is my reading of 4108 right? Is this, and it's on tape, this is on videotape. Am I correct in my interpretation of that? The solicitor said, sure, yeah, that's the right interpretation. 1 week after, later after that meeting, the very next day after that meeting, a commissioner writes an email to the rest of the commissioners copying Mr. Decker. We either rein him in so that's our direction the county moves in, or we end our relationship with him. So that's what happens. That's part of the retaliation, that he had the gall to suggest a reassignment of an employee from one department to another. Rein him in. Again, we are now 5 months after the Public Integrity Commission rebuked the commissioners. Mr. Decker saw the writing on the wall. On September 19th, 2 days after that meeting, he finds himself he writes an email and says, I find myself in a somewhat impossible position because I've tried to serve the entire governing body, not just a few select members. I've been subject to retaliation. This increased when I made a referral to the Public Integrity Commission. Whatever the case may be, I believe the cause of public ethics best served by transparency. That was September 19th. 5 days later, without complying with 9 Delaware Code 4108, which requires a preliminary notice of removal. And here's the statute itself. Here's how, if the commission wanted to follow state law, here's how to remove a county administrator from office. The county government may remove the county administrator from office before the expiration of the administrator's term, but only in accordance with the following procedures. By affirmative vote of a majority of all the members of the county government upon adoption of a preliminary resolution, which shall state the reason for the removal. On September 24th, a week after the dust-up about the reassignment of the department employee, the Levy Court went into executive session during a business meeting and voted to terminate Mr. Decker's employment. There was no adoption of a preliminary resolution which shall state the reason for the removal. It was just a backroom agreement that Mr. Decker had to go because his commitment to ethics. I cited the statute again because, as you'll note, the requirement is that you adopt a preliminary notice of removal or a preliminary resolution which shall state the reason for the removal. What is cited here is state law, not the county code, not some type of municipal ordinance. That is state law. Shall state the reason for the removal. The commissioners are required to state their reasons if they're going to try to remove a county administrator. But at the September 24th meeting where he was terminated without a preliminary resolution, not one commissioner stated his or her reason for the removal. Violation of state law. In fact, when the preliminary resolution was ultimately adopted, it even said it was without reason. So the commissioners, I guess, learned that they had not complied with state law. There had been no preliminary resolution at the September 24th meeting. So we fast forward a week later, and the commissioners now have to do a do-over. They now have to try to comply with state law after they've already violated it. So they have another meeting, a business meeting, and this time you adopt a preliminary resolution. Well, respectfully, the game is over by that point. You've already made your decision. You've already voted to terminate him a week before, without reason. But on October 21, you do the preliminary resolution and you say directly, it's without reason. Here's what the law provides on whether or not, because I understand that one of the positions that commissioners may take is that, well, he's got a contract, and the contract says we can terminate him for no reason. Ladies and gentlemen, that contract is completely unenforceable under well-established Delaware law. You can't make a contract, you can't put a provision in a contract with a county employee that violates it as a contravention of Delaware state law. It's about as basic as law gets. But for the benefit of the group here, I cited the law here. When a municipal employer enters into a contract with its employee that the employer did not have the authority to make, the contract is ultra vires, which means without authority, and unenforceable. And there's a citation to a case against Newcastle County. Delaware law provides that a municipality cannot act in conflict with state laws. This rule derives from the fact that the state, as sovereign, is the original source of the legislative power, even though it has chosen to delegate much of that authority to the municipalities. And I cite the case there. And it's not just municipalities. Delaware preemption authority applies to counties as well as municipalities. And here's the case. It's a federal court case, Freeberry versus Coons, that says all of these things. So you can say he had a contract that says we can terminate him without cause, but I would refer you to 9 Delaware Code 4108, the state law. The General Assembly says you can't terminate Mr. Decker unless you state a cause, a valid legal cause. It's never been done. So those are the state laws. Here's the federal laws. Whistleblowers Protection Act. It is clear, the record is clear and undisputable that Mr. Decker was subject to retaliation for complying with this ethical obligation to refer a matter to the Public Integrity Commission. Delaware Whistleblowers Act protects him from you retaliating against him. Here is the language of the statute. I won't read it into the record. It's already part of the record as part of the presentation, but it's basic law that if an employee exercises his right to make a referral to a public body, you can't take adverse employment action against them. That's exactly what happened here. Here's the other state law that I made reference to, the FOIA provision. This is the provision I referenced earlier in my presentation that requires that a meeting like this must include time for public comment. Here's the rest of the law on the public comment. It has to be included in the agenda. You're aware of that because you amended the agenda tonight. Agendas can only be amended at the time of the meeting for an issue that arises during the meeting. There can be no argument that the commissioners just became aware during this meeting that they have an obligation under the law to provide public comment. Now, is that a technical violation? No, because we have the right, and the public has the right, to rely upon the agenda that is published in advance of this meeting. I have it on good authority that the form agenda that the county uses includes public comment. So somebody removed it when it was originally posted, the provision for public comment. So we have an agenda that was posted for this meeting that did not allow for public comment. Where does that leave me and Mr. Decker in preparing for today? Well, it's not easy to call witnesses who are going to be subject to cross-examination. So we could rely on people to come in and provide public comment on Mr. Decker's behalf, and there would be plenty. But we had no notice. Nobody told us that there would be public comment. It wasn't in the agenda, and you can't revise the agenda tonight to include public comment. It had to have been in the original one. So it's not a technical violation. Mr. Decker has been prejudiced in his ability to present his position at this hearing by the commissioner's noncompliance with state law. Federal law, 14th Amendment, due process. Due process protects people's interest in life, liberty, or property. That's in the Constitution. You cannot interfere with a citizen's life, liberty, or property. Well, what life, liberty, or property did Mr. Decker have that the commissioners interfered with? Under the law, an employee who has a position created by state statute, which the county administrator here is, by 9 Delaware Code 4108, that person has a property interest. Under the law, that person has a property interest in his employment. So, Mr. Decker had a property interest in his employment under the law. The county cannot deprive him of that without due process of law. There are two types of due process. There is procedural due process, which means providing him with a meaningful opportunity to challenge the decision to remove him from office, and substantive due process, which means you must have legitimate reasons to do it. You can't be arbitrary and capricious about it. In this case, the county's removal of Mr. Decker from office violated both his procedural due process rights and his substantive due process rights. I don't know that the county could have tripped over itself more procedurally in trying to remove Mr. Decker from office. September 24th, you vote for termination without any reference to 4108's requirement of a preliminary notice of removal. It comes to your attention and you try to fix it a week later, and you finally issue the preliminary notice of removal. By the way, what happens to Mr. Decker before you even gave him the preliminary notice of removal? When you voted to terminate him illegally on September 24th, you took away his access to his email, took away his access card to the building, you blocked him from emailing from his personal email other employees of the county. You did all of that before a preliminary notice of removal. That's illegal. That's a violation of his due process rights. Then tonight, the whole inability to provide public comment on his behalf. All of these procedural missteps along the way. Like I said, respectfully, and it's not going to sound respectful, and I apologize. It seemed to me that the county couldn't walk from here to there without making a procedural misstep when it came to terminating Mr. Decker's employment. And that's just the procedural aspect of it. The substantive aspect of it. Constitutional law requires that to deprive him of his property interest, you have a reason. The plain language of your preliminary notice of removal and the plain language of your final removal will be without reason. That's damning. That's a violation of federal law. It's a violation of his substantive due process rights. Last, federal law, First Amendment. Here is the elements of a First Amendment retaliation claim. That Mr. Decker engaged in constitutionally protected activity. Of course he did. Making a referral to the Public Integrity Commission is a constitutionally protected activity. Number two, the government responded with retaliation. We've already gone through how the county tripped over itself trying to remove him from office. And then number three, the protected activity caused the retaliation. In other words, was it Mr. Decker's referral that ultimately resulted in the adverse employment action? Of course it was. It's an open and shut First Amendment retaliation claim. So Mr. Decker has multiple state law claims, multiple federal claims, all of which on an undisputed record would render the county liable for his removal from office. The county has unfortunately violated state and federal law multiple times, and that is why we are here to demonstrate that. So, ladies and gentlemen, that is the end of my initial presentation. Unless there are any questions of me, I would like to move to the portion of the hearing where we hear from Mr. Decker.
Sure. Mr. Decker, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yes. Proceed.
Mr. Decker, can you tell us a little bit about your professional background before accepting your appointment as county administrator?
Academically, I have a bachelor's degree from Gonzaga University. I hold a Master of Public Administration degree from Eastern Washington University. I'm a graduate of the University of Maryland's Academy for Excellence in Local Government. I've been professionally active. I've taught courses in local government for the Maryland Municipal League and the Maryland Association of Counties. Professionally, Kent County was the 4th local government that I had served as the Chief Administrative Officer of. I have been a local government CAO for over 20 years.
When you became employed as the county administrator with the county, did you have an employment agreement?
Yes.
Okay. Did that employment agreement last for a duration of time? Or did you have a?
Yes, it was a 4-year employment agreement.
Okay. Before you signed the employment agreement, did you read state law that applied to your position as county administrator?
Yes, it's a fairly common practice for city managers or county administrators to read the law that would govern the performance of their professional position.
Did that law, was that law what we were just talking about, 9 Delaware Code 4108?
Delaware Title 9, Section 4108.
Okay. And did the provisions of that law affect your ability, affect your decision to accept the job?
Yes, one of the reasons that I accepted the position is that many county governments operate under what's called the old commission form of government. Some, roughly 800, operate under the commission manager form of government, where the position is defined in statute, either in local ordinance or in state law. It's particularly strong when it's in state law because the governing body can't amend it itself. The governing body has to go to the state legislature and ask for the law to be changed. So the fact that the position was clearly defined in state law, as a chief administrative officer, I felt gave the position some kind of definition that I thought would be advantageous to me trying to perform the job.
In connection with your appointment, did you get a sense of whether anybody else at the county seemed to have a grasp of 9 Delaware Code 4108?
Well, when I first mentioned it, it seemed something of a surprise, particularly as it relates, the state law makes it, I think, very clear that the county administrator oversees the administration of all county offices. The finance director in Kent County, however, is an appointee of the Levy Court Commissioners. So there was some dynamic tension there because as I read state law, the county administrator has administrative oversight over that department. I don't believe everyone in the organization, including the finance director, shared that perspective.
Was there any, compared to your experience before being hired by the county, was the structure of the county any unusual for you in terms of whether there were department heads and things like that?
No, I think the structure was largely similar. The function was different than the other county governments where I'd served, given the degree to which commissioners were involved in administrative matters. I was not accustomed to that. But I think in terms of the operational departments, honestly, it was less technically complicated than the last county I managed, Caroline County, Maryland. Kent County doesn't have roads, doesn't have a correctional facility. While it's a smaller county population-wise, there are more, I guess, functional departments. But in many ways, it's a fairly typical structure of county government.
In addition to your testimony you're giving now, did you submit a written reply to the preliminary notice of removal?
I did.
Okay. And I think we can stipulate that that reply has been provided to the commissioners. Okay. In your reply, you made reference to something, terms that you called the old guard here and the new guard. Can you explain that?
After I was appointed, I made an effort to try to meet with each commissioner individually at least once to try to get a sense of what the dynamics were on the governing body. In meeting with 7 commissioners individually, 3 of those commissioners have been in office 4 or more terms. I informally thought of them as the old guard. 4 of the commissioners had served considerably less time. In fact, 2 commissioners were elected not long before I was appointed. I informally thought of them as the new guard. Based on those individual meetings, my sense was that the new guard wanted to see a change in levy court operations, where there would be more participation from all of the commissioners, where there would be more transparency, more information shared. So that direction I had from what I determined was a majority of the commissioners shaped my administration during my 18 months.
So you started employment on March 1, 2023 as county administrator. Can you describe for us what your first 10 months or so was like throughout the rest of 2023? So March 1 of 2023 to December 31, 2023?
Yes, I think it was an interesting year. I think there were some immediate challenges coming into the county in the middle of a budget cycle. As you've already discussed, the issue with the conflict of interest with the Public Integrity Commission first came to light during my first month here. That was a bit of a surprise. I think the most dramatic thing that happened was a ransomware attack that occurred on July 8th of 2023 that effectively shut down county computer operations for roughly 60 days. The response and recovery from that was extraordinary. It also occurred at a time when the county had taken on several major initiatives. The implementation of a new software, enterprise-wide software system, the first reassessment of property values since 1987, the disbursement of federal COVID relief or ARPA funds. Those are the kind of challenges local governments would normally try to take on one at a time. These were all happening concurrently, so it made for an extraordinarily busy year, but on the whole, I thought the year went relatively well.
So that's up to December 31, 2023. Did the dynamics of the levy court change in 2024?
Yes, well, and it actually started, I think, in late winter when the incident that you talked about involving a state employee who apparently complained about my conduct during a Zoom meeting I had with a member of the county senior management team, and there was a suggestion or allegation that I had engaged in bullying behavior on that Zoom call. I spoke to the other county employee who was on that call. They did not feel that my behavior was untoward, but and around that same time there was a push to do a performance review, which led to some conversations about the continued allegation, and I had questions in terms of, I had not really sat down and met with the group about professional expectations, about a format, so, but I felt like the bullying narrative, which I believe was false, and that's, as you referenced, where I had asked for an outside investigation that was never conducted. I asked multiple times for that investigation to be conducted, and I was told by one of the commissioners that I was just overthinking the performance review, that it was just this bullying concern that some of the commissioners had. That was the first indication I had that my position was becoming more tenuous.
What was your impression when this bullying when you asked for the bullying narrative to be publicly investigated and be the subject of a public hearing?
Well, I believe I've already gone on record, whether it's in emails to the commissioners or things I've said in the written reply, is I think the commissioners pushing the narrative knew that it was false and that an investigation would vindicate me in my position that I had not engaged in that behavior. The other individuals who reportedly complained were never identified to me. Nothing was ever put in writing. So I think once I stood up and said I wanted the investigation, my impression was the commissioners lost interest in pursuing it.
Let me turn your attention now to what you heard during my presentation as your referral to the Public Integrity Commission back in March of 2024. And just for the benefit of the record, that referral, would you confirm that the document that's being shown as an exhibit is that referral?
It is.
Okay. Can you give us a brief summary of that referral from your perspective?
Well, I think the referral was my trying to take all of the information that I had received since March of 2023, providing it to the Public Integrity Commission with the intent of having the PIC provide an opinion on whether they felt it was a conflict of interest or not.
When you made the referral to the Public Integrity Commission, were you making an accusation against anybody?
I was not.
How would you characterize it?
I was asking for an opinion for the benefit of the Levy Court as a body.
And that referral, as we see on the exhibit, was made in March of 2024. And we know now that it was because of a conflict of interest of one of the commissioners. Did you ask anybody to investigate this before running to the Public Integrity Commission? In other words, did you talk to anybody about this issue before?
Yes. Yeah, before I made the referral, I communicated with individual commissioners, including a commissioner who had sought an opinion themselves from the Public Integrity Commission regarding an obligation prior to their election, and that elected official had received guidance from the PIC to recuse themselves from any decisions related to that particular entity. In the course of that conversation, I was informed that another commissioner had agreed to make the referral. As a simple matter of due diligence, I waited roughly 30 days. I contacted the PIC directly to ensure that that referral indeed had been made. It had not. So feeling like there was no one else that was going to do this, and despite being the least senior person involved, I made the decision to make the referral myself.
Mark, would you mind scrolling down to the signature line of this document? Thank you. The large paragraph after number 23 paragraph reads, I hope that Commissioner Pepper and/or Commissioner Sweeney would have referred this matter to the Public Integrity Commission before now. That apparently has not happened, and it leaves me in the unenviable position of making a referral that risks negative professional consequences. What did you mean by a referral that risks negative professional consequences?
Well, I think any time that an elected official perceives that something's been done that's an attack on them, that elected official can then retaliate in any number of ways. So what I was not accustomed to in Delaware, which is different from Maryland, is in Maryland, a referral to the Ethics Commission is fairly matter of fact and not seen as any kind of an attack. It's simply that you're going to get guidance, and as a matter of state law, local governments are required to have a local ethics commission, so getting opinions is a fairly routine matter. That has not been my experience in Delaware, and I think that statement was informed by the time I'd made that, I'd been with the Levy Court for roughly a year, and I had heard from staff people with whom I worked who I thought were credible and trustworthy, that in the past that Levy Court commissioners had engaged in retaliatory behavior towards employees for actions that the commissioners did not approve of.
Why would you do something that would, in your words, risk negative professional consequences?
Right is right. I mean, public ethics are public ethics. The rules should apply to everyone. That's been a cornerstone of my career in public service. It goes back to my time serving in the Navy. We all need to abide by the rules. No one should be above those rules. And just from a pure liability standpoint, just speaking pragmatically, it's far better to go to a public ethics commission or a body and get an opinion than to take action and that ultimately puts the county at some kind of legal risk for improper behavior.
Mr. Decker, on the prior exhibit, we saw that you copied the Levy Court commissioners with the referral. Why did you do that?
Throughout my career as a city manager, county administrator, I've always tried to communicate with the entire body, not with one single member, although having worked in a strong mayor environment, that was a little bit different, but I also think as a matter of professional courtesy, if I'm going to say something, I'm going to stand behind it. So when I emailed this, because I sent it as a PDF to the Public Integrity Commission, I copied the Levy Court commissioners on that email, because if I'm going to say it, I'm going to stand behind it, and I'm going to make everybody aware of what that concern is. I think that's just a fundamental professional responsibility.
We saw in the prior document that the referral was made in March of 2024. This document is the decision by the Public Integrity Commission. It's in June of 2024, 3 months later. In that 3-month period, did any of the Levy Court commissioners provide a response or their version of events to the Public Integrity Commission?
To the best of my knowledge, no.
And is that document that we're looking at on screen, is that the response from the Public Integrity Commission?
It is.
I don't want to have to read it into the record, but can you summarize what the decision was of the Public Integrity Commission?
The Public Integrity Commission determined that the commissioner did have a conflict of interest.
Did the Public Integrity Commission commend you for making the referral?
Yeah, embarrassingly so. I don't think that anyone should be praised for doing something that they think is simply the right thing, but yes, they did. Did
the Public Integrity Commission express its disappointment that you had to make the referral?
Yes.
Okay. In your opinion, did your decision to make that referral lead to retaliatory action by the commissioners?
Yes.
Can you elaborate on that?
I think that the Levy Court, at least in my limited experience and based on what I know, has a long-standing tradition of keeping things in-house. I think my decision to take something outside of Levy Court and make that report crossed, for at least some commissioners, a clear, bright line that it wasn't going to be handled internally, swept under the rug. It was that I had gone outside, and I certainly felt the strain in the relationship I had with the commissioners as a body and with individual commissioners to have increased after the referral was made.
Were your ethical concerns about just this one incident or about something more system-wide?
Well, I think during my tenure, there were other incidents or situations that gave me cause for concern. I think the second referral I made to the Public Integrity Commission, which was the meeting that occurred just before I was terminated, was regarding a statement about why the Levy Court Commissioners in 2021 requested the state legislature amend that section of the law.
Mr. Decker, can I stop you there?
Sure.
Because I neglected to mention the second referral during my presentation. So would you mind factually explaining what happened with what prompted your second referral to the Public Integrity Commission?
So there was the meeting, and I believe it was on September 17th, so forgive me if I'm incorrect in my recollection of the date, where there was a discussion about transferring a position, and not to correct my attorney, but it was the transfer of a position, not a person, because no one had been hired to fill the position that had been vacant in finance since January. That led to discussion in workshop before and after the business meeting. Part of that discussion was over what the role of the chief administrative officer is and the authority as established by Section 4108 of Delaware state law. And I made a number of observations, including the one that even if all 7 commissioners voted to direct me to take an action that was administrative in nature, and I think I used the example of terminating a classified employee, I would respectfully decline to do that if it, in my opinion, was the wrong decision to make. There was clearly some fallout from that interaction, and I received an email from a commissioner, and part of that email was that the real reason that Section 4108 was changed was to allow a county administrator with minority support of Levy Court commissioners to terminate an employee. And in my over 20 years of doing this, I'd never read anything quite like that, because generally speaking, and I'm not naive, and I don't think every law that's ever been passed was passed for the reasons that people said they wanted the law changed. I had just never read a local elected official admitting that a state law had been amended for a purpose that was covert in nature. And I have no way of knowing, but I expect that that came as a surprise to some of the commissioners as well. Having no idea what exactly to do with that, I forwarded that email to the Public Integrity Commission and said, and I don't want to try to quote myself, but effectively, I've never seen this before. I don't know what to do with it. And I think that ethics referral also resulted in retaliatory action.
When you say you think that second referral to the Public Integrity Commission resulted in retaliatory action, when did you make that second referral to the Public Integrity Commission?
I believe it was on September 19th or on or about. Isn't that the way lawyers always say it if they don't want to be quoted? But I think it was 2 days after the meeting.
And then what happened at the next meeting?
I was terminated.
So it was within 5 days of your second referral to the Public Integrity Commission the levy court voted to terminate you?
Roughly. I'm not going to count them out in my head, but yes, it was the next business meeting.
How were you notified about that?
When the commissioners returned from executive session, after being asked to sit at the dais, the commissioners voted to terminate my employment.
You mentioned earlier you're familiar with the Delaware statute, the state statute that applies to your position, right?
Far more than I ever expected to be.
And were you aware before September 24th of what the state law says must be observed by the county if they want to remove your position?
Well, I mean, I think you quoted it, but I've been in local government for a long time, and one of the things that I know as close to an article of faith is that local laws can't preempt state laws. That's just, counties and cities are political subdivisions of the state. And as unpleasant as it often is, because many state laws are burdensome, unfunded mandates that make it very difficult for local governments to function, you don't get to ignore them and you don't get to change them. You just have to live with them.
Speaking purely procedurally, did the commissioners comply with that state law when they voted to terminate you?
While not wanting to be accused of practicing law without a license and reading it as a layperson, I do not believe that the levy court complied with the requirements of the law.
What actions did the levy court take against you after they voted to terminate your position?
Well, if you're referring to, I guess, my departure, is that after the termination occurred, my access to the building was terminated. My work phone was deactivated while I still had it in my possession. I was locked out of my county email account. I had to make arrangements to come back to clean out my office under supervision. And just, while I don't want to sound intemperate about this, at the same time, the county had an employee on administrative leave pending a pre-termination hearing, and that employee was allowed to remain on administrative leave with access to their email and with access to their county phone. So from my perspective, I was treated in a manner different than that employee.
Do you believe that the county's effort to remove you from office has been directly related to your referrals to the Public Integrity Commission?
Yes, but I think that's an incomplete answer. I think some of it is directly attributable to the decisions I made. I believe it was also a result of a realization that the levy court commissioners had that whatever the bullying narrative, whatever anything else, is that I was not going to alter my ethical compass for any reason. So in some ways, I think it was intended to avoid future instances of me making referrals or simply refusing to comply with directives that I thought were unlawful or within the space of the chief administrative officer to decide.
We're coming to the end of your testimony now, so
Thank you.
just a couple more. All right, Mr. Decker, are you proud of the work you've done for the levy court, for the county?
Yes. Yeah, I think that some of the best work I was able to do as a public administrator happened during my 18 months. I had the privilege of working with some of the finest public employees that I've been able to serve. I think the quality of the workforce improved. I'm proud of the promotional decisions I was able to make. I'm proud of the people I was able to participate in hiring. I'm amazed that some of the projects actually went as well as they did. The reassessment, and having lived through much uglier reassessments, I think it went incredibly well. So in terms of the positive work that I was able to do with the support of a remarkable team, I could not be more proud.
Well, Mr. Decker, given that your actions as county administrator have resulted in the county's efforts to remove you as the county administrator. Would you do anything differently, knowing what you know now?
I might have tried to step up my wardrobe to keep pace with my assistant county administrator at the time, but otherwise, no. I think that I felt like I had a choice between losing a job and losing my sense of integrity and losing the respect of employees, and I feel like I made the right choice, and it's a choice I would make again.
Mr. Decker, today is your day for the hearing. I think we've covered everything.
I hope
but
so.
I don't want to walk out of the hearing without you having the opportunity to say anything you would like to. So is there anything additional beyond the responses to my questions that you'd like to say?
I had written some brief notes, and I think it's been covered exhaustively, but I do want to talk about one particular aspect of my employment. That one of the first events I attended as a county employee was a fundraiser for Derek Thomas, a paramedic. He was on medical leave, and he was battling cancer. And he hadn't been an employee for a terribly long time, but I was incredibly impressed by not just the public safety department, but the overwhelming support that he felt. And the employees were great about donating leave to Derek, but that wasn't sustainable. So I drafted an extraordinary leave policy, and credit to the commissioners, they adopted that policy. And that policy allowed the county to keep Derek on paid administrative leave until the end of 2023, and to keep him on our medical benefits until he passed in August. Sorry, this is a tough one for me. At the end, his experimental medical care was $25,000 a month for one medication. And when he was on leave, I wrote handwritten notes to him at least once a month while he was sick. And he rarely responded. And I totally understand and respect that. But over the course of the illness, I started talking to his mother, Sandra, and we developed a relationship. And the morning that Derek passed, she called me. And I felt horrible that I wasn't able to attend his services because I was traveling in Montana at the time. But I told her that I really wanted to be able to get together with her and her husband. And after September 24th, I unexpectedly had a lot more free time. So we made time to sit down together at lunch. And they were incredibly gracious. And they thanked me, but when I had my chance, I made sure that the public safety employees, the employees of this organization, and you as county commissioners received credit, because it wasn't something that I did. It was something this organization did. So for a moment, or for a time, this organization was the kind of organization that was worthy of Derek Thomas, of a fellow military veteran and a person who wanted to dedicate his life to public service. And he didn't get that treatment because he was politically connected to somebody. He didn't get that treatment because he was a commissioner's relative or a friend, or because it was going to make some state official happy, or there was some kind of vested interest. It was just the county doing the right thing for the right reasons. And that's what the levy court could be if it could consistently put the community and the employees ahead of some of the petty political things that I've had to deal with. And I'm not here to criticize levy court. I'm sorry that things ended the way they did. But for the sake of the employees here, I hope that levy court can find a way to be that organization. Because I want the levy court to be successful. I want it to figure things out and provide the kind of leadership that could really make a difference. Because I've seen what it's like when that happens. And I've received accolades, honors, different things. Nothing that's ever happened to me professionally means more to me than Sandra and Daryl Thomas mentioning me by name in Derek's obituary. That to me is worth everything. So I hope the Levy Court, whatever it chooses to do, can be that kind of organization. And with that, I'd simply wish you good luck and good night.
Thank you, Mr. Decker. I don't have any more questions, and although I intended to do some type of closing or summation, I don't think it would be anything other than redundant of what you've already heard, and I don't want to waste the time of the people who are here. I know the 4108 allows us to present our positions for a hearing, and I think we've done that. So with that, I think the hearing can be concluded.
Thank you, Mr. Griffith and Mr. Decker, for your presentation tonight. As mentioned earlier, we did add the public comment to the agenda. And at this time, we'll open the floor for public comment. We'll ask those folks that are here for public comment to come forward one at a time, and please keep your comments brief and please under 5 minutes, please.
And I would just like to reiterate my objection to the public comment given the FOIA violation.
Thank you, sir. Yes, sir. Please come forward. Please state your name, your address, and be sworn or affirmed by the county attorney.
My name is John Kirby. My home is at 2025 Highland Avenue in Dover.
Sir, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I was very impressed by the presentation. I'm not a lawyer. I'm just a citizen. And some may think my comments are intemperate, but I promise they're not profane. They're not disrespectful. And thanks to the First Amendment of our Constitution, which guarantees my right to free speech, please don't shut me down. I have read State Law Delaware Code Title 29, Chapter 58, Paragraph 5809, with regard to the establishment of the Public Integrity Commission. I've also read the decision of the PIC that concluded that Jody Sweeney, while a commissioner of the Kent County Levy Court, was guilty of a conflict of interest. I've also read Mr. Sweeney's claim that the decision of the PIC must be kept secret and could not be shared publicly. Frankly, that's patently ridiculous. Why have a Public Integrity Commission and keep their decisions secret? I've also read Mr. Sweeney's response to the PIC decision and his campaign response to his challenger, Susan Lamson. It is my respectful opinion that Mr. Sweeney is arrogant, disrespectful, petty, self-serving, egotistical, and entitled. He seems to feel that we, the citizens, are his subjects and not his employer. I love Kent County. At the age of soon to be 80, I expect to age in place and live out the rest of my life at my current address. However, I must also say that I'm ashamed of the behavior of one of the commissioners of my Kent County Levy Court. I've also read Delaware House Bill 221 that greatly expands the role of the county administrator. It is natural that the Old Boys Network would push back and resist that change. I've been through a similar situation in New Jersey before I came to Delaware, where the organization wanted to professionalize its management, and the elected officials, who are part-time in nature, had to turn over more of their work to the administration. And I was that CEO and administrator, so I'm aware of this type of situation. However, there's a way to resist and a way to accept and welcome the inevitable. It is my opinion, and just my opinion, that Mr. Sweeney's behavior and his comments went way beyond what is acceptable. He had a right to appeal the PIC's decision, but instead he chose to have the county attorney simply say he wasn't guilty of any such thing. I know Mr. Sweeney has served the county well over many years. However, given all the above, and to preserve the integrity of his legacy, I believe the proper course for him would be to immediately resign from Levy Court. Failing that, and to maintain the integrity of the Levy Court, the majority should thank him for his service and seek his removal for, quote, misconduct in office and, quote, corruption, unquote. With regard to Mr. Ken Decker, I see him as a breath of fresh air and an asset to the county in an environment that has been resistant to change. If his dismissal is not reversed, it will be a loss to our county, and he will have fallen on his sword in an effort for the greater good that was for no self-interest. Thank you. John Kirby.
Thank you, Mr. Kirby. Anyone else?
Hi, my name is Diane Rager. I live at 127 Front Street in Frederica. I'm also the Chief Deputy for the Register of Wills.
Ms. Rager, do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
Proceed.
I don't have much prepared, but I really just wanted to express my disappointment that Ken was let go. I thought that he was on a path to make some changes. The first thing that I did, of course, with probably a lot of other people, when they heard his name, they Googled him to see who he was, what he did. And what I saw was someone who wasn't afraid to make change, even if it wasn't the way of the government. But he wasn't afraid to make that change. And I thought in the beginning it started to be changed a little bit. We started having public workshops that would last for 2 or 3 hours, where the staff and all 7 commissioners could sit and talk about not what was coming up on the agenda next week, but IT upgrades that needed to be done, upgrades for my office. When I say my office, I mean the Register of Wills. Code enforcement needed some things so that they could do their job properly. The building's 20 years old, you needed maintenance to be done. Just routine maintenance that wouldn't have come up on the agenda or no one would have known about. But without that workshop, it wasn't for all 7 of you to hear. It's just what 1 or 2 or 3 people wanted to be put on the agenda. In the caucus room, there's 3 whiteboards that have lists of projects that need to be taken care of. Some of them have to come before Levy Court and need to be done. Some of them don't. But I don't know what happened. I don't know where the breakdown was. But I can tell you that I had an issue, and I still have an issue, with an elected official in a register of, recorder of deeds, who continuously meddles in my office, meeting the Register of Wills. I've spoken to quite a few of you, and your comment to me is that's just the way she is. Don't worry about it. Well, that doesn't work. Ken tried to do something, and I hope that wasn't part of the retaliation to get rid of him because she voiced a concern or filed a complaint against him about her bullying. She has been the biggest bully there is in Kent County. And I'm just here, I just want to say that. And I'll let you know, I had intended to work out till 2026 in the Register of Wills, but my last day is February 28th because I cannot see us going backwards in time, and I can't put up with you guys, not you specifically, but I'm not going to let the last 2 years be bullied by someone else. Thank you for your time.
Thank you. Anyone else? Please give your name, address, and be sworn or affirmed, please.
Good evening, Mary Ellen Gray, 215 Chapel Drive, Camden, Delaware.
Ms. Gray, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Proceed.
Thank you. Thank you. I am disappointed. As some of you know, I'm a planner, and I believe very much in the process. Process is the cornerstone of good governance. And when we don't follow the process, all is lost. We lose transparency, we lose the trust of our people, of our citizenry, and we lose the trust of our staff, the people we work with, and the people we work for, and the people we serve. I've been in public service for, many, many years, too many to count. And I take, and all the people I've worked with and have worked for, public service is very important, and the integrity is very important. And when you don't, we've heard evidence here tonight, irrefutable, regarding evidence on the record that the process wasn't followed. And that is very disturbing to me and disappointing that the leadership here at Kent County is not following the process. And that raises a question in my mind as a citizen: if you're not following the process for something as important as letting go a county administrator, your leadership, what else aren't you following? You all need to really take a good look at your processes and procedures, and you are not above following them. You need to follow them, because as I said, that raises the integrity of the office, of your office, as well as the public trust. It also has impact on the future. When you're looking to hire another county administrator, that county administrator, whoever you're looking for, there's an arms race out there for county administrators and leadership. They're going to be looking at this record, and what are they going to be seeing? So you all have to, I think, take a good look at your, as I said, processes and procedures, and hopefully this will be a learning moment and a crossroads for a turning point for this Kent County Levy Court. And I hope that this will be, as I said, a turning point for you all, and we can move forward in a positive direction. Thank you.
Thank you. Anyone else like to make public comment? Any more public comments? Mark, or is anyone online that would like to make public comment?
If there's anyone joining us online that would like to make public comments at this time, please indicate by raising an electronic hand or pressing *3 if you're joining us by phone. I see no hands raised at this time, Mr. President.
Thank you. Lauren?
Thank you. I just have just one quick comment. I've only been with the county since January of this year, and I came to work under the leadership of Ken. In my previous job, I had met with him and admired his leadership and his integrity, and that is one of the main reasons why I wanted to work here with Kent County. I was born and raised here. I love everything about this county, and I like the direction that he was taking us. Thank you for your service that you have spent here.
Thank you. Mark, there's no one online. Okay, great, thank you. Okay, that concludes the proceeding for this evening. This will be the close of this evening's public hearing. There is one other item under other business. Commissioner Angel.
Thank you, Mr. President. Move to go into executive session immediately following the business meeting for a preliminary discussion on site acquisition for publicly funded capital improvement, legal strategy session regarding collective bargaining or pending or potential litigation, and personal matters pursuant to 29 Del Code 10004 B24 and 9.
And that will be next Tuesday evening, correct?
12th.
The 12th.
Second.
Thank you. Motion was made for executive session on the 12th of November. It's by Commissioner Angel, second by Commissioner Sweeney. Any questions on that motion? Seeing none, Mr. Knockham, we have roll call, please.
Mr. Angel?
Yes.
Mr. Hall?
Yes.
Mr. Hertz?
Yes.
Mrs. Maston?
Yes.
Mr. Scott?
Yes.
Mr. Sweeney?
Yes.
Mr. Pepper?
Yes.
Mr. President, roll call reveals 7 yeas.
Thank you. We will have executive session next meeting, the 12th, to discuss the proceedings here tonight. And with that being said, I need a motion to adjourn this evening.
Motion to adjourn.
Second.
Thank you. Motion by Commissioner Maston, second by Commissioner Sweeney. Can we have roll call, please, on that?
Mr. Angel?
Yes.
Mr. Hall?
Yes.
Mr. Hertz?
Yes.
Mrs. Maston?
Yes.
Mr. Scott?
Yes.
Mr. Sweeney?
Yes.
Mr. Pepper?
Yes.
Mr. President, roll call reveals 7 yeas.
Thank you. We are adjourned this evening. We will be leaving and not coming back, but I would like to certainly thank everyone that came here this evening to either participate or hear the public hearing that we had performed tonight. So thank you very much, and we are adjourned. Thank you.
Personally, busy.
Thank you for seeing it. You too.
Mark, thank you very much for everything. I really appreciate it.
never seen anybody so happy as the guys.
How have you been? I'm good. I saw you come up. I was like, hello. I know. How have you been? Good.
Oh, yeah. He has the ability, I just, talk a lot. Well, thank you so much. I look forward to hopefully meeting you at more social